Hi, I'm attorney Michael Kerin. I practice workers' compensation in the state of Connecticut. If you've been injured on the job, I think I can help you. I've created this video so that you can do a virtual walkthrough of a claim from day one till day done. It's got some useful forms that you'll probably need to complete and some procedures that you'll need to go through in order to get a successful outcome in this system. If you think I can help you, I'd like to have that opportunity. Please give me a call at this office. Thanks so much.
Injury and first report of injury form. The first step is to report your injury as soon as possible to your supervisor by means of a first report of injury document. Even if your injury seems minor, it is very important that it is done as soon as possible. The longer you wait, the more suspicious your case looks and the more likely it is to be denied, which will not only delay your benefits but risks you not receiving them at all. If your supervisor writes a summary of your injury, be sure to read it carefully and make any necessary corrections before signing it. Medical treatment and first medical report. The next step is to get treatment. Find out if your employer has a managed care plan, which requires you to see a specific facility for medical treatment. If they don't, you are allowed to be treated wherever you wish. One of the most important documents in a workers' compensation file is the first medical report, so be sure to be as clear and accurate as possible when explaining to your treating physician what happened, why it happened, where it happened, and when. If information does not make its way into the initial report, it can be very difficult to establish your case later on. Form 30C. Next, you must file a form called a 30C. This form is an official request for compensation for your injury. Even if you reported your injury to your supervisor and filled out a first report of injury form, you cannot receive any benefits or compensation without filling out a Form 30C. For most cases, this must be done within 1 year of the date of your injury. However, there are exceptions to this rule. It's important to contact an attorney to be sure that this is done in time, or else you risk losing your benefits and compensation you need. Out of work slip. If your physician keeps you out of work, you must get an out-of-work slip from your physician and provide it to your immediate supervisor. If you don't keep your supervisor in the loop with the situation of your injury, it can result in your termination. Although companies are not allowed to fire you for filing a claim, they are not required to indefinitely hold your job open while you cannot work. If you are out of work for a substantial amount of time, the company may need to replace you and you might be fired. It is best to keep in touch with your employer to give you the best chance at continuing your job after you recover. Denial of claim, health insurance, and disability benefits. In nearly all cases, your employer's workers' compensation insurance carrier will immediately file a Form 43, which is an official denial of your claim. They will likely argue that there isn't enough information to establish that an injury happened on the job. If this happens, your case will become stagnant until a hearing is requested. If you have health insurance through your employer or otherwise, your health insurance carrier is required by law to cover your medical expenses. Some employers offer short-term and long-term disability benefits which may be available to you in the event that the workers' compensation carrier denies the case. Informal hearings. If a Form 43 is filed, it is essential that you contact an attorney immediately. Your attorney should fill out a hearing request form. There are 8 district offices in which workers' compensation cases are heard in Connecticut. Generally, you will be given a hearing within 3 weeks of your request, depending upon the district in which you were injured. If you are being represented by an attorney, you will not need to attend the initial hearings, known as informal hearings. These only last about 15 minutes and are attended by your attorney, an attorney or adjuster of the workers' compensation carrier, and the district commissioner who hears the case. The purpose of informal hearings is to determine if agreements can be made between your attorney and the workers' compensation insurance carrier regarding your benefits, treatment, and compensation. The Commissioner does not make demands from either party, but rather strong recommendations, such as recommending the carrier to begin compensation payments in the anticipation of an agreement being made. Formal hearings. If your case cannot be resolved through informal hearings, your attorney will request a formal hearing, which is the equivalent to a trial. Trials in this forum are allotted 4 hours of testimony, and if the case cannot be completed in one sitting, it will be continued to another date. Unlike informal hearings, you must attend formal hearings. These are used to settle disputes such as if your case is compensable or if you should be entitled to receive certain types of treatment or benefits. Light duty work. At some point, your doctor might tell you that you can return to work, but only in a light duty capacity. If this happens, you have to return to your employer to see whether they can accommodate your restrictions. If the employer cannot accommodate you, then you are required to do 5 job searches per week. If you refuse to return to your employer or to do the job searches, you will become ineligible for current and future benefits. Stipulation. Your attorney may recommend that your case become settled by means of a document known as a stipulation. A stipulation offers you a lump sum of compensation in exchange for any rights to benefits you may have. The amount of compensation is determined by factors like how much work you have missed, how much more you are likely to miss, your prior medical expenses, and any medical expenses you are likely to have in the future. Once a stipulation is signed and cleared by the Commissioner, you no longer have the right to any benefits outlined in the Workers' Compensation Act, such as disability benefits, payment for future medical expenses, and lost earnings caused by unemployment or having a new job which pays less than the job at the time of your injury. The value of all this should be factored into the stipulation. The only right you will still have is the right to vocational rehabilitation. Vocational rehabilitation. Vocational rehabilitation is a process for which you can apply to get reintroduced into the workforce. Physical, intellectual, and psychological evaluations are done to determine what type of rehabilitation is best for you. You will receive help aimed at getting you a job that best suits your condition, which can range from a job for your previous employer or vocational training for an entirely new field.
I hope you found the video helpful. If I can answer any questions you might have, please don't hesitate to give me a call. Thanks.